Welcome back, everyone, to another episode of Triumvir Unplugged. We're extremely delighted to have with us Trisha Mitra Veber and Simon Weber. Uh, uh, Different surnames, they're not related, and we're good friends, and always a pleasure to speak to them once again. We also have Paras, who's an associate partner with us at Triumvir Law. And like always, we'll be discussing all things international law and international disputes. But this episode particularly will be a bit more fun because we're gonna delve into a bit more nuanced aspect of career, personal anecdotes, and a lot more in relation to careers in international disputes. But before that, I mean, they might be our friends, but you might not know who they are. So, Trisha is a senior associate at Reed Smith. She's been a prolific international disputes lawyer for over a decade right now, and she's dealt with complex disputes over various arbitral disputes. She's also a peer editor with the Oxford Journal of International Law. If that's correct, right, Trisha?
Yeah, with the
That's
Oxford
the
University Press. I'm a peer
Oxford
reviewer
University
there.
Press. Fantastic. Yeah. Um, yeah, we're going to keep it short. You can read about them more. We're going to link it when we post about them. And Simon, Dr. Simon Weber, as he would like to be called. Not
Absolutely
really.
not.
But yeah, Simon is an old friend. Simon is an associate at Quinn Emanuel Urquhart in the Zurich office. Uh, he also deals in complex disputes across institutes and jurisdictions. We've had the pleasure to work together in several instances, collaborate, and other than professional connections, good friends, and just a pleasure to have you on board and see where this conversation goes. Uh, um, to begin this conversation, I would take the conversation first to Trisha. Uh, how did you decide from being from the Indian subcontinent, right? Where you are either thrown into uh, the deep ditches of the litigation world, or the long hours of the corporate world. When and how did you decide and that you wanted a career in international disputes or wanted to do something remotely related to that?
Yeah, I mean, you're absolutely right. Back in the days when I was a student, and that's quite some time ago. When I was a student in India, international disputes, international arbitration was not the go-to career choice for many. I had one course on it in my final year. But the way I discovered it is by hearing about it through the various arbitration moves that happened. And the first time I heard about it was, I think, the NLS arbitration moves. And I was like, well, what is arbitration? And sort of hearing about um, a dispute resolution process that was efficient, that was quicker than some Indian litigations can be, piqued my curiosity. So I did many internships. I did a diploma course on arbitration, and even then, I was not satisfied that I had learned enough or really understood it enough. So right after law school in India, I decided to join a disputes boutique in Bombay. And there I was in the deep trenches, Anubhab, as you call it, the deep trenches of litigation, but also doing the long hours.
Yeah.
Um, and well, before I moved to what I did afterwards, I must say that those years doing litigation, and as any litigator in India will know, you're never doing just a couple of them, right? You're doing large volumes of litigation at a time. So really that cut out my litigation instincts, which I now carry with me in my arbitrations. But in Bombay, I was doing mainly litigation and not that many international disputes. So that curiosity remained. So that's when I
Right.
decided to do a master's, a master's in international dispute settlement, the MIDS in Switzerland. And that sort of kick-started my international disputes, my international arbitration journey. It has now been a decade. I am now in London, but London is the fourth jurisdiction I'm working in. So I started my career in India. I practiced in Switzerland as well. I was a tribunal secretary to Professor Pierre Tessier, who's also my professor at the MIDS. And then I worked in Paris for about 6 years with Sherman and Sterling, working under Emmanuel Gaillard and Yasvana Fatemi, which was fantastic training to be to start one's career in arbitration. And then I moved to London, where I was with Laliv, again a fantastic team. I was very lucky to be in teams that were doing a mix of both investment and commercial arbitration.
Right.
And now I am with Reed Smith, continuing my international arbitration journey, back at an American firm which has global presence, and so very lucky to be back in an international practice.
That's interesting that you say that, because like I've had a discussion. I mean, I've happened to say this on a public forum as well, and I think the concept of international disputes team in India is still a very developing concept, right? You don't have a team purely doing international disputes, right? You have a team which might be doing international disputes as a part of it, right? But the majority of a fee earning, like, from a fee earner's perspective, is your regular disputes, like, might be like, arbitrations. It might be international arbitrations. It might be domestic arbitrations. It might be NCLT, like, so like a whole gamut of general litigation, so to say. But having worked both in, like, the deep trenches in Bombay and in so many jurisdictions abroad, like in Paris, London, uh, do you feel that there are similar setups of teams there, like, which are pretty generalist, like, in terms of disputes? Or in your opinion, it just, it's better to have international disputes team, especially like, dealing with investor state arbitrations, purely specific and, specialists?
Yeah, I mean, that's a very good question. And it's something that I've been thinking about recently. I find that team compositions at firm varies, and I think it is driven by the volume of international disputes they have. So where firms, so for both in London and Paris, there are some firms who will have just a disputes team and sort of an
Right.
international arbitration sub team, but if that sub team is not busy, they will be doing the other disputes. And there are a few firms that will have a dedicated international arbitration team. A lot of that is driven, I think, by the volume of international arbitration work that they have, or just by other revenue decisions, the structure of the firm.
Right.
What we are also now seeing is the rise of arbitration boutiques. And those boutiques will only do international arbitration work. So I think India is not the only jurisdiction where there can be a large disputes team that also does international arbitration. I think that is a trend that you see sort of across the world.
No, yeah.
Yeah, so Trisha,
Yeah, go
I
ahead.
just had a follow-up question, and Simon, this is a question we would love to have your take on as well. Trisha, you mentioned that, through your career, you have worked both on investment and international commercial arbitrations, right? Uh, so from the perspective of someone who is probably just a year into his or her practice, or, someone who's still studying in a law school, when we talk about investment arbitration and when we talk about international commercial arbitration, what are the different skill sets lawyers should look at equipping themselves with, especially considering the fact that, when it comes to commercial arbitration, at the end of the day, we are basically dealing with contractual obligations. The stakes are much higher when we talk about investment disputes, because, we are also dealing with the question of state sovereignty. There obviously has to be a certain uh, difference in terms of approach, when you approach the dispute itself. But the host that, if the two of you were to, sort of talk about the skill sets, what would you pick?
You're absolutely right. I think the theoretical underpinnings of commercial and investment arbitration are different in the sense that, like you said, Paras, commercial arbitration largely arises from some sort of an agreement, largely, not always. So being absolutely clear on contractual, on contracts law is absolutely essential. And while in international arbitration, the case on your desk can come from anywhere in the world. It could be the contract law of a country, of any country in the world. I think whether you're a common law lawyer or a civil law lawyer, knowing the contracts law on, let's say, under common law or civil law is very, very important. You should know the contracts law of your jurisdiction. And for investment arbitration, a lot of it, again, not all of it, but a lot of it is public international law. And again, sort of having a good understanding of public international law is very important. But at the same time, even in investment arbitration, you are often seeing a lot of contracts. Ultimately, the cause of action could be a concession contract, a mining permit, all those kind of things, regulatory documents. And the good part is that while at least back in the day when I said when I was a student, I didn't have arbitration courses. I had very good contract courses. I had very good public international law courses. So while I did a master's then to sort of build on that and see how that applies to international disputes, I had my foundations clear. So I think those are things that are accessible no matter where you are studying in the world.
I think you had also the access to the person who had drafted I think one of the main books of contract law was from Symbiosis, right? If I'm not wrong. She was the dean. Yeah,
Yes,
right? At
yeah, that's
Symbiosis.
right.
So having access to, such a, professor is fantastic. Simon, I would just turn to you now. I mean, how would you explain is a normal day in a life of an associate of an international disputes lawyer? It's the most general question that there can be, but there's a lot that can be said about it, right? Like, how does a
There
day
is
look?
there's a lot that can be said about it, and I think there's a lot of people who are trying to make a business out of that as well in all jurisdictions, where they come up with new TikTok and Instagram accounts showing their life as a lawyer in a big firm.
Yeah.
Listen, it's a very interesting day. Usually, every day is usually interesting in an international firm. I have the habit to always have a little black booklet, which is my to-do list, in which everything is noted so that I don't have any scribbles on notebooks or something.
So you're a
And in the
handwritten kind of a
morning,
person. You're a handwritten kind of person, not a to-do list like a Microsoft to-do or whatever.
yeah, I'm not using any apps for that or whatsoever.
Okay.
I have I have this little black booklet that I always use. Everything is in there. So I consult that in the morning, and I go through my emails because my inbox is also a to-do list. So I use Outlook I always file my emails, and everything that I've read is filed in a subfolder of the project, and then a subfolder of the work stream. So I always find emails, always know where they are. But yeah, coming back to my inbox, it's a to-do list. If there's something that I still need to do, or if something is in that email, then I know that it remains in the inbox until it's done. So that's the beginning of the day. I go through all emails that have come in also overnight, because if you work in an international law firm, there's colleagues that work in other jurisdictions.
Correct.
So I get organized on my day. Then usually, at least here in our office, you have a call from a partner probably who wants to catch up on what's happening. You need to coordinate with the other offices on projects that you're working on. I work a lot with our Paris, our London office, and also with our Boston and Washington, Miami offices on projects. So the beginning of the day, is usually a start into this what I need to do. And then yes, the rest of the day is depends then on the season you're in, right? If you preparing a hearing, then you know that there will be lots of meetings and calls. If you know that you're preparing a submission, then there's lots of drafting, research, aligning with the team. And in the evening, you try to leave whenever you can to grab food. And depending on the workload, you might respond to some emails in the evening again and go to bed.
I mean, I think for the last time we spoke, to both of you, I think we had isolatedly discussed about, how, there's a shift in the culture in work in India, right? Like, and, how the preference in terms of working is changing as well, right? So, so there's a huge dialogue which has now started about, for example, work-life balance, which is earlier it was a conversation, now it's maybe is being affected, right? So when I started my career, I remember that it was still a conversation, right? And I started my career in a firm called Cyril Amachan Mangalas, right? And at that point of time, we didn't really have a work-life balance, which was put to play, but we did have you know, mechanisms in place where we could address ourselves, like, there would be therapists and so on and so forth in office. So, but now it's more of a practice that people want to implement, right? Uh, in your observation, like, in your day-to-day working, how has firms in and across around Europe been able to you know manage this whole concept of because our like let's just admit it that the service driven industry, it might often be a utopian concept, because if there is something that needs to go out, it needs to go out, right? There's very little that we can do about it in terms of hearing, but there is still a need and a demand for work life balance and balancing the scale in a way that everybody does, like, gets their free time, that they're not burnt out, and they have longevity in the career. So what each one of you, what do you think your takes are on these?
You want to go first, Trisha?
No, go ahead, Simon.
I think so. Work-life balance is obviously a very important topic, and it has gained
Right.
importance in the past years, as you've said, Anubhab. Ultimately, I think every lawyer is responsible for it themselves, because you are the one who either goes and takes up more work, or who has to speak up if you have too much work, and then you need to use the tools that the firm is responsible for, and the firm has to implement, right? So, in a way, you need to be able to know your limits. You need to know how much you can work and how to structure your days. I think there are people in the industry. There are firms who think that it's a very important topic. You have billable hour requirements that are almost non-existent. You say 1,500 hours per year. You say 1,800 hours. Those are all targets that then hopefully make your life a bit more chill and not as stressed as if you have to get up to 2,000, 2,200, because this is ultimately what
Right.
then depends. This is what it depends on, how you feel. If you at the end of the year you're like, oh my God, I haven't done enough. I'm not reaching my targets. You're getting stressed. Then the next thing is you should always be able to somehow do your sports. Movement is so important. I've come to notice in the past, I
Yeah.
think, 7 years. You need to know whether you do it in the morning, if you can do it over lunch, in the evening, if you're happy doing it on the weekends. But I think going outside, doing your sports, going to the gym, playing tennis, football, whatever you want to play, I think it's very important for your mind that you also have that kind of consistency. So make sure that you get that in. Then we are living in a world of international dispute resolution, in which sometimes you have deadlines, sometimes your entire rhythm gets completely messed around with. That happens, and I think
Right.
people who work in the industry and in international dispute resolution, big firms, or doing the big disputes, you just know crunch time. There's very little you can do about it. Just cope
Right.
with it, and then it will get better afterwards. I think that has always been my approach. I'll just deal with it. I'll do it, and then it will get more chill afterwards.
Yeah, I think I completely agree with Simon. I mean, there's no getting around the fact that the life of a disputes lawyer is very demanding.
Right.
Whether you're doing it internationally or domestically, it is a very demanding profession. As someone who is now more and more managing teams, I think that leaders of teams have a big part to play in ensuring work-life balance.
Exactly. Exactly.
As of course, as you go into more of a leadership position, you start being able to manage your own time. Number one. Number two, if you can communicate with the team and tell them, well, actually, originally I told you I'm going to look at this on Monday, but I'm not going to have time until Tuesday evening. That helps them then manage their time and maybe go to that dinner that they were about to cancel. That's number two. Another thing that I have now started seeing with some clients, and which is them asking questions why we are emailing them on a weekend or late at night when there is no immediate deadline coming up, there is no filing coming up, there is no hearing coming up. And now it depends, again, like I said, the leader drives the attitude of the team. I have seen some leaders of teams, be it partners, whoever, who say, okay, you know what, let's see how we can become more efficient in our work so we are not working on weekends or working late at night. There are, of course, still leaders who are saying, well, work, but just send the email at 9 in the morning. But I think clients are realizing that if their lawyers are overworked, they're probably not being as productive as a well-rested lawyer can be.
Right.
So that's the second part. And the third part I want to talk about, and this is going to make me sound old, is the work ethics that the new generation is bringing in. So they are demanding more work-life balance. There is silent quitting that happened sort of post-COVID, where they said, well, big law is not for them. I think that disputes will continue to be a demanding profession. So people who are signing up for a dispute career need to be ready to do that work. It is good, I think, to demand work-life balance when there is no immediate deadline. But I'm also seeing juniors who very close to a deadline are saying, well, we have a dinner with our friends, so we are going to log off at 6 p.m. the night before a filing. And I think that is going a bit too far. And I don't think that is great. I don't think that's great teamwork. So I think that is where I would caveat saying work-life balance is very, very important, but disputes is a demanding job. So there will be times of the year when you need to put in those long hours. And unfortunately, then the balance is tilted in favor of work rather than life.
Right.
But hopefully you can then
Exactly.
reset that at a different time.
Right.
So
And I think it's very important, one thing that actually you raised, Trisha, and that's teamwork. That's something I've noticed in the big arbitrations that we're doing here. As long as there's communication among the team and the team works together, then you spread the work evenly and you make sure that everyone also knows what is happening. That creates a lot better balance throughout the entire project.
Absolutely.
So one of the things that we implement is, for example, there's a submission, and and it's something that has to be done. There's a SLP in before the Supreme Court, right? And the client wants to draft, let's say on a certain time, and we are short of time. We've received documents late. We are busy collating documents, and we have to put the draft out, and it's maybe a humongous matter, okay, where there's extremely voluminous, and the associates are up late. As a practice, like Paris would know, what we do is one partner is always up with the team of associates working. And what we do is that like we do half an hour or 1 hour or 2 hour calls to check and take updates of any problems, or if we can help, so that they don't feel isolated in the whole process, that they're in this alone. So I think that is something that has helped us a lot in making them feel a part of the team. So
Yeah,
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 That sounds very
so we have spoken, when we talk about work-life balance so far, we have spoken about attitudes and behaviors, leadership, communication, and sort of trying to manage your own timelines at a personal level. But if we take a step back and we talk about the process itself, because as a disputes lawyer, and especially someone who does a lot of arbitrations, I think 70 to 75% of the work we do is with documents, and sometimes these documents can range into thousands, 20,000, 25,000 pages that you have to review, and sometimes at a breakneck speed. So, when we talk about work-life balance in that context, how do you see the role of AI? Because, obviously,
yeah, I was just gonna come
post-pandemic,
to that.
we have
Yeah,
seen this influx of a lot of AI-powered tools who sort of, I mean, as a lawyer, you cannot extract yourself from the process, but once these AIs have been trained on a large amount of data set, you see that they sometimes take away a large part of your work. How do you see the influence and role of AI going ahead, and probably saving you some time or just making that task a little more easier?
I'm happy to go first. So I think when it comes to document management and document review, I think AI has been around for a while in the legal profession. AI
correct.
has become a buzzword recently. But in
Right.
all the practices that I've been part of, we've been using document review tools like a relativity, etc., for years. No doubt they are becoming better. Those systems are becoming more sophisticated. So Reed Smith is right now testing several AI tools. We are likely going to start using tools that will help us summarize documents as well. So when we're receiving millions of documents, we'll have these tools that will help us summarize them. But we've already been using tools that help us sort out relevant documents, deduplicate them. So really bring down, if you've received a large volume of documents from the client, bring it down and make it a more manageable size. Now that's not always the manageable size varies depending on the case, but definitely I think AI will, as we see this evolve, and I think what's gonna happen at a breakneck speed is the evolution of AI. We will see how we'll definitely be spending less time, which is great for the client, I think, at the end of the day.
Yeah. I mean, Matt, I've seen that, we've worked with funds and we've worked with, big conglomerates who've actually asked us whether we use AI. So, at the outset, you don't understand whether they're asking this question as a detriment or to assess whether you are actually going to do better work for them. But I was quite shocked to know they asked these questions to understand whether we are able to manage our time better and use technology better. And they actually wanted us to use AI and tell them that yeah, we do use AI to manage documents, to create first cut of certain templates and so on and so forth. And I was quite and
Absolutely.
I mean, Paras, Ajay would love for this to be shared. So we are our new partner who joined us recently. So Ajay is also a tech guy. He codes and all of that. So he's created a model for us called Goo, which he's trained with all Halsbury reviews, all Oxford University Press review, articles, all the databases that are there. Okay, and it's trained them with separate case models as well. So we use that quite frequently, and it has made our lives fairly simple. Of course, we also believe in human intervention and final touch and all of that, but it's been a game changer. Simon, what's it been like for you?
I think AI is a huge chance and opportunity for the legal community. There's a lot of
Right.
people who say that it might take away our jobs and you will never need a lawyer. I do not believe that at all, to be honest.
Correct.
I think AI will make our lives well, easier, more efficient. It will make legal submissions hopefully more correct, better, more comprehensive. It will contribute to the perfection of our job and our tasks. But I do not think that will ever take away our jobs. I think we will all have to learn which kind of AI is out there, right? Which kind of AI we want to use, how it can be used, and then how it also can be trained, right? There's different approaches to submissions, to whatever, even document review. Different jurisdictions require there's different regulatory requirements. It always depends on the order of the court, what you need to do with documents, for example. All of that can obviously be taught to the AI. I've seen a lot of very interesting AI models recently. A lot depends on the underlying data set that the
Right.
AI has available. I would love using as much AI as I can. Obviously there's this whole moral discussion about AI becoming too dangerous, too powerful.
Right.
That's something that just needs to be dealt with, I think, right? You just have to set out the limits of the AI. I'm way too little informed about the actual programming process, even though I'm more or less a tech guy, actually. Also, everything that has to do with whatever kind of technology, be it whatever computers, or be it the gas pipelines or gas compressor turbines or whatever, I'm interested. I know how they work. Also, in our big disputes, I always end up getting in my eyes, the fun part of getting to deal with the experts and having them teach me what they're doing, so that I can also make sure that this is what is required for the case. And it also contributes to a very helpful exchange, by the way. If you as a lawyer understand the technical intricacies of the underlying businesses. But to get back to your question, lawyers should not only be users of AI, lawyers should also understand AI, I think.
I think that's crucial. That's crucial. If you don't understand how an AI behaves, I think the whole point is to use it is somewhat moot. I mean, you will obviously get responses, you get, first cut drafts and all of that. But now that you mentioned expert, and how to deal with them and so on and so forth, I mean, we come to our next segment. We've tried to create a fun bit in here, and we'll want to go with Trisha first in this. So this is something that we call explain to a 4-year-old. Okay. So, so, and
As long as it's
what?
not, are you smarter than a fifth grader? It's fine. That's fine.
No, it's not that. It's not that, but it's not that easy as you might think, Trisha. So what we do is we ask you a question. We would expect you to explain this to a fourth grade, like a 4-year-old, in as bare bone as possible to see if they understand or not, right? So how would you explain what investor state dispute is to a 4-year-old? I've tried doing moral damages, by the way. So
Right. I'd be very concerned if a 4-year-old is asking about investment arbitration, but they probably have lawyer parents. Investment arbitration is when the government of a country does very bad things to uh, a project that is not owned by someone who belongs to that country.
I'll just say that this can be 7 out of 10. It was quite explanatory, but there were use of tough words. But
Okay.
yeah, so but yeah, we would take that. I mean, yeah, bad things. I think they would stick on bad things, and I think that would be explanatory. Simon, for you, how will you describe what a cross examination is?
We can cut out this break afterwards, by the way.
Yeah, sure.
Am I related to the 4-year-old?
Uh, Not necessarily.
Okay, I'm explaining it I'm explaining it to Trisha's daughter now. The 4-year-old daughter. Okay, listen. So when mommy works very, very late at night, and mommy really has a tough life at the moment because she's preparing for an important work event. Well, in the evening when she comes home and you ask her about work, your mommy feels like she's being cross-examined, like the people she is working with in a hearing.
That I think that would go. I think that would
Yeah,
go.
we'll
Well
take it.
done, Simon. We'll take that. We'll take that. That's great, guys. I mean, Uh, if a 4-year-old can understand that, I can totally understand how sad a life that kid is going to have. And I hope not. I really hope not. Uh, just taking the conversation ahead, uh, in terms of differences in arbitration styles between, you know, uh, you know, you know, different jurisdictions, right? And this question is particularly maybe for you, Trisha. Like, we are, India is like, an English speaking country, so to say, like, we practice in English, like, there's a demand for it, and, there's demand side is completely separate. But, like, you've practiced in like heart of Paris, and like I've spoken to you, and I've spoken to several lawyers who are like, who've not been native French speakers, so to say, who've worked later on in, Paris. And in generally in the field of international disputes, there's a huge requirement you know, for your ability to be able to speak, several languages, right? But we know we growing up are taught English and something else, like, for you maybe Bangla, Hindi, for me similarly Bangla, Hindi. Simon, I know, knows can speak like a lot of languages, right? Like, French, Spanish, German, I don't know what else. But
No,
how has it
no
been?
Spanish.
No Spanish? No hablas español?
No, no, no.
But I mean, how's it been for you, Trisha? Like, adapting to that, or is it not a consideration has it not been a consideration in your career so far?
Yeah, it's a very good question, and one, Anubhav, that a lot of people who are trying to break into international arbitration ask me. Should I go do that crash course at Alliance Française? Should I go learn a Spanish course? Should I take up a Russian course? Um, so I'll first start off by saying that we Indians do know that we are all multilingual in India.
Yeah, yeah,
It's just that not too many of the languages we speak are business languages, at least internationally.
correct.
I think the only time I've ever used my Bangla is when I was at Sherman, and the New York office was doing a real estate deal I'm guessing in India or Bangladesh, and they had like these real estate sale deeds in Bengali that they wanted me to translate in English, and frankly, my Bengali was of no. So listen, I think a large part of international arbitration still happens in English
Right.
in many of the jurisdictions. So and the way now, if we're talking about the Indian early practitioners, young practitioners, what they should be leveraging on is their fluency in English. Because that is not a given in many jurisdictions. In Paris, I was considered in the group of native English speakers with my Kiwi and Aussie and English colleagues. So I
Was
think
it
that is
was it
where.
was it considered to be an advantage because was it a dearth of English speakers in your organization at that point of time, like who were
Yeah,
proficient
there was
as
no
native speakers?
dearth, but I think, for example, grammar, sentence construction is very different in certain
Mm-hmm.
Latin languages as compared to English.
Mm-hmm.
So I would often be sent drafts to sort of just rework the phrasing and the structuring to make it more attuned for, let's say, an American arbitrator or a British arbitrator. So I think that's where, being a native fluent English speaker gives you a high leverage. I think it's always good to learn a foreign language. It's always good
Right.
to learn sort of these languages are spoken, but the reality is that a Spanish client is not going to come to me if I've just done a crash course in Spanish. What it will help me probably is if I know conversational Spanish and I'm in a meeting or at a dinner with them or at a drinks with my clients, that helps me sort of build a relationship. So
Proper.
it's good for client relationship building. But the reality is, I mean, I have good levels of French, but I'm not but legal French, number one, a legal language is very different from conversational language.
Correct.
So for example, legal
Mm-hmm.
English is very different from from regular
Absolutely.
English, right? So just because someone's from India doesn't mean they know legal English.
Right.
So it's good to take on an additional language, but don't do it so that you can work in Russian or in Spanish, because that frankly is very hard to do.
By the way,
Simon, you've been
it's very important. Sorry to interrupt you, Anubhab, but I find it very important what Trisha is saying, by the way, because
right.
so I speak three languages more or less on the same level. That's English, French, and German, and I work in all three languages. Everything, pleadings, memos, whatever, client relationships. I can draft submissions, and that has been I find that's one of the most important things as a lawyer, as Trisha has also said, is to be able to communicate in these languages, not only in a restaurant, but also use the legal language, right? In the
Huh.
past probably 12 years, I studied in Germany, in France, and in England. And it's always been an obsession of mine to more or less perfection my written skills in the three languages. And it's also been a huge advantage, right? I work on French cases, where you need at least French. We recently won a big arbitration where the client was German, and it was very helpful to have a complete German speaker on the team who could also speak in, normal high German. There's different types of German.
Right.
And then also be able to kind of take all this information and then spit it out again in English, for example. So I find language skills are really, really important, and I would add that to the list of things that Trisha used or listed in the very beginning of our conversation of how you can become a lawyer, how you become a lawyer in international dispute resolution. You should absolutely be able to speak a few languages to a certain level.
No, absolutely. I mean, and that goes without saying. And I think that skill is so relevant because this is something that I understood that, for example, Trisha and Simon, when I was in The Hague, finishing my master's, I had classmates who were of Asian descent. And, in Asia, you're made to believe that, you have to perfect your English, right? Simon, like, that it's a cultural thing that, at least in the middle and the upper societies in India, if you make a grammatical error, you're ridiculed, right? Because okay, oh, your tense was wrong. Okay, so we're made to perfect our English, absolutely, right? And however, the importance and I've seen a lot of these Asian students wanting to, let's say, take a crash course in French, take a crash course in Spanish or whatever, to maybe get a fellowship in the ICJ or the PCA, so on and so forth, or a firm in Paris. But then you know it shouldn't be a reactionary move also. I believe that just to get a job, to learn a language, I think it should be a process where you know where you learn a language because you learn a language so that you add to your skill set rather than for you to be able to get a job. And that's my
Absolutely.
takeaway. Yeah. My personal high was when I was able to understand the poster in the ICJ where there were two zebras, and one zebra tells the other, my mom was black and my dad was white. And the other says, oh, yeah, mine was just the other. My mom was black and my dad was white. And it was written in French. So I was like, whoa, I, I understand that. So that was a personal high for
Well
me. And
done.
yeah, I truly boasted about it for the next week or so. Because my wife is I think, a C1 French speaker,
My
Pallavi.
French is really good. Her French is really good, and I know her French.
Yeah, you've spoken to her in French, so yeah, so
Yeah.
so yeah, she was like, "Stop it now." So yeah, so yeah, but in the Indian context, right, we still don't work a lot in Europe, right? Our disputes are a lot of, let's say, like we are a lot in demand in the Middle East, right? But still, there's a lot of requirement for English-speaking lawyers, right? In Dubai, okay, and I think. Don't get me wrong when I say this, but I think that English also is, of course, is one of the most important languages, right? And it should be one of the perfections. But like we have French speakers in our team as well, because time to time we do get, you know, inquiries and so on and so forth. And when we file for capabilities, we also have to, like, you already know that we have to say that whether we have those capabilities in our team or not. But Simon, have you written legal, academic pieces in, let's say, um, German or French, like, or has it only been when you work, or like you've dealt with these languages when you work?
No, I think also, well, I have published in German, that's for sure. I'm not entirely sure if I've published in French. I would have to look at the
Okay,
list of publications, but I think so. I've gone through the entire French legal education. I have a licence en droit, un master 1, master 2. I went to Nanterre University in Paris,
okay.
which Trisha knows as well. There's lots of public international law being taught there, which at the time sparked my interest in public international law. So no, I think I have published in both languages, in all three languages.
It's interesting that you say this because, like, if you ask me to, even write something in Bengali, okay, which is my mother tongue, I would just leave the building. Okay, it's. And I mean, I think the same for Paras, like in Hindi, right? And I think the same for Trisha, like writing in our vocations in like our own languages are so difficult, right? That we're not taught. So the amount of preference in English that we've been given is incredibly high. So
I mean, I
um,
get that. I also have preferences. I clearly prefer working in English by far.
okay,
I mean, that's 80% of my work is in English, I think. Then maybe, I don't know, 15 in German and 5 in French at the moment. But that's clearly the case. But just because I have preferences does not mean that I should not work or publish in the other languages.
right.
It's obviously, I mean, if I think about it, I was brought up in the south of Germany by a Swiss mother and a German father, and my Swiss family has English and Canadian roots, and comes from a bilingual part of Switzerland where you speak French and German. So, and then you can push this story even further. My Swiss family speaks French and Swiss German, which is a dialect. My German family speaks a dialect called, well, it's some sort of Swabian. It's in Bavaria, but the
All
place where
right.
I grew up has another kind of German, the Bavarian, that they speak. So, in my head, even as a young boy growing up, there were plenty of different languages already, English, French, and dialects. I'd have to say I grew up in German, I think, mainly. With my mother,
Hmm.
if she did not want my brothers to understand what she was saying, she spoke to me in French. And
Hmm.
then kind of everyone spoke English because you've been taught English from a very, very early age. So I can clearly say that some languages are probably more eloquent than in others. That's
Right.
absolutely the case. And when I draft and do stuff in French, I would always ask one of my French colleagues to just confirm that what I've done is makes sense. But
Yeah.
also here within the firm, the client communication with some of our French-speaking clients, I can just do it. It just goes through me.
That's interesting that you say that. And I mean, on that note, I mean, I have something else to ask you, which is our next segment where we try to discuss the funniest thing you face in an arbitral institute, right? And during an arbitral process, right? And I would start with Simon first on this, right? Because we all have our stories, and why not share them? Of course, if you want to take names, that's
The funniest thing that has ever happened to me in a dispute, in a hearing or in our
in a hearing,
general,
in a hearing, in a hearing.
in a hearing. Some arbitral institutions are in cities where mice are a problem, right? And some, irrespective of how new the building is, I mean, Trisha, you know it obviously from London as well. There's you have the pest control comes over every other week, I think. So I remember a dispute where we had just started the hearing, and then there was this teeny tiny itsy bitsy mouse just running from one corner of the corridor to the other, and the chairman was just about to go through the list of participants, and we all saw the mouse, and he was like, "Okay, and we have an intruder here, or is that a witness?" Um, or is that someone else of the legal team? Or is that a client? Who is that? Oh no, is it my tribunal secretary or is that my alter ego? So it was a very funny statement that the presiding arbitrator made, and
There's literally a mouse.
it was literally a mouse just running through the room, and we all saw it because it was very confused in the very room. I think that was, you had the entire room just burst out of laughter. Probably the way I recall the chairman's statement is wrong right now, but this is kind of the joke he made at the time. So it was off to a very, very good start.
Trisha, did you have a mouse run about in your arbitration proceedings?
Not in my arbitration proceedings, but in Paris, most buildings are infested by mice. So I've had several of my cereal boxes in my desk being chewed through to a point where I just stopped storing food on my desk. But yeah, that's mice is a real problem in international arbitration.
Maybe we should publish something on this.
That's the conclusion. Exactly. That's the takeaway from this session. The next change is that mice are the biggest issues in international arbitration.
Well, I could go on forever.
We probably need another working group to discuss how to remove mice from international arbitration.
Well, the real best in international arbitration.
We need a working group 5.
Reed Piper of Hamlet.
I'm trying to remember funny incidents. I was once in a very acrimonious investment arbitration case against sort of a top practice in Paris. And it was one of those cases where there was a lot of procedural back and forth. Like every week, we were sometimes sending up to like 15 letters inter partes. So there was a lot of back and forth between the parties. And once we had a filing, so I was the one in charge of doing the filing. It was a long submission. I send it out to the other side, and within 2 minutes of my email going out, I receive a response from the partner leading the other team, and it's only to me, and it's one word. Seriously? Question mark.
How did you respond to that? Oh, did you respond to that?
I was stumped. I was stumped. Number one, very senior partner. At this level,
how long back is this?
I'm going to say about 5 or 6 years ago. Okay. So I was mid-level, where, you take lesser liberties with responding to senior practitioners. But I didn't let it go. I called up my partner, and I was like, I've received this email. I don't know if it was meant for their own team. Maybe he thought he was writing to one of their associates, but did a reply instead of forward or something. And he's like, yeah, I'll let it go. If you just want to send a response saying, by the way, you sent this to me or something. And I was like, I've got one even better. So this partner had written to me with one word, right? Saying, seriously, question mark.
You could have responded with the one word, yes. Please tell me you did that.
Yeah, so that's what I know. I replied saying yes, full stop.
That's what I would have done.
Fantastic. Did you hear back though?
I did not hear back, but the partner did bring it up at the hearing, and he was like, that was really funny. He had a good sense of humor. He has a good sense of humor. So it became good banter at the hearing.
Good fun. Good fun. I mean, for me, it was my witness who showed up faking a heart attack at the emergency ward and tried to video call the tribunal from there and was convincing me that I should, ask the leave of the tribunal to be able to, postpone the hearing. Okay, because we had, we were pursuing, judicial actions before the Supreme Court to stay the arbitrations so that, these arbitrations and he was adamant that, he has a heart attack. So he wanted to speak to the tribunal over video call to explain to them that, and off the record that, he was dealing with certain ailments. And I did ask, and I won't take names obviously, but one of the arbitrators, two of the arbitrators were Singaporean, and one of them were a retired judge of the Supreme Court. And Trisha, I think there's an echo from your end. I could hear myself. Yeah. And what happened was he was explaining to the tribunal that he's having heart ailments, while a nurse from the emergency ward said that, left him in Hindi. He said, "Isko jaane do, kuch nahi hua hai." Okay, and, and the Supreme Court judge, who was proficient with Hindi, understood that and said that, I want your presence in the next 3 hours. Otherwise, your right to, file an application would be closed. And, everybody was like on the floor. But we come to the end of this session, and it's been great, speaking to, not, practitioners, but friends. So I'll just leave you with one last question to the both of you, right? Um, if you had to do it all over again, starting now, would you guys do it as international disputes lawyers?
100 times over.
And
Absolutely.
actually, I'll just expand that question a bit, right? One is if you were to start over all over again. The second is if uh, you were to start all over today, what would you do differently than what you did
Yeah.
back in your days?
As a person, I generally don't look back, and I try not to have too many regrets. So I don't know if I would have done too many things differently. I would have definitely, this profession for me, my own career path, I couldn't have dreamt it. I sort of went with the flow, and I'm happy that it's shaped up the way it has shaped up.
Right.
Now, of course, there are sacrifices that you make, spending time with family, with friends. Perhaps
Right.
that's the one thing I would have changed, but not to the extent where I would have wanted my career to look any different than it does
And then
today.
you won't cancel work because you have a dinner with your friend at 6 p.m.
Definitely not as a young practitioner.
Okay, Simon, what about you?
I don't think that I would change anything. No, not at all. I do not have any regrets whatsoever. I tell people that I've always kind of done what I wanted to do next. I was in Germany for 2 years doing my studies. Then I moved to Paris. And after 4 years in Paris, I was like, okay, I want to live and work in an English-speaking country. Moved to London. It's a very unusual career path. Also study path, right? But it's in international dispute resolution that has proven very, very helpful. I love my time. I love my time in London. I worked for the great Martin Hunter, for the great James Crawford. A lot in my career as well was just pure luck, I guess, that someone has introduced me to these people. Someone thought of me. Hey, Simon, you have a certain skill set that we require right now. Why don't you come? I've quite frequently taken my chances, and I'm very happy about how it turned out. Maybe if you were to ask me the question, what would you do if you were not to become a lawyer, right? Then I would have to think about it. I'd probably either open a dive shop or a bakery.
Bakery. I thought you were averse to sugar.
I am adverse to sugar. Well, I do not eat that much sugar. I mean, now that I'm in Switzerland, I do eat chocolate from time to time, believe it or not. But I really like baking bread.
Okay. Sourdoughs. No, on the point of Martin that you mentioned, and I think we've spoken about this isolatedly online, personally as well. I think there are very few people I know who've changed careers, you've changed lives, and you have good bosses, you've bad bosses, you've good mentors, you've bad mentors, but there are very few people who just unabashedly, without any agenda in mind, purely for the good on their heart, pick somebody up and then, give them a chance of a career in whatever they want to do. And it's extremely rare. I mean, I from one haven't, met anybody like him, and they're not. And the very reason I'm at least sitting here and doing whatever related to international disputes that I do is 100% to do with him. And
I couldn't agree
yeah,
more. Could not agree more.
yeah, yeah, yeah. I mean, to be given a 21-year-old guy from, a law school in India a chance to go to Essex Court and, stand in an elevator which is shared with Malcolm Shaw, you don't really, that's an opportunity you don't get like, day in, day out. So yeah, truly. On that
I think
note,
mentors make or break your career sometimes.
absolutely, 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 absolutely. Okay. Thank you so much to the both of you. I think this has been our funnest episode. From what we've started since we
I
started.
will attest to that. I've been there for every episode.
And thanks to the both of you for being absolute sports. And yeah, I mean, and we look forward to meeting you not for this Friday's lunch, but sometime soon when we visit London, which we intend to do soon, or Switzerland when we do. And this time it won't be just a drink, Simon, like the last time we did in Zurich. So yeah, hopefully soon.
Absolutely. Thank you very much for having me and for inviting. It was great seeing all of you, at least virtually. And I
Yeah,
hope that the session is as much fun to your to everyone, to the audience, as it was being on the panel.
absolutely, absolutely.
Yeah, it's always a pleasure, Anubhab, talking to you. It's always a pleasure doing something with Simon, and it was really nice meeting Paras. And I love the podcast. I've been listening to a few of the episodes, and I was very happy to be invited on it.
Thank you so much.
Lovely.
Thank you.
And
Thank you, Trisha.
hope it has the
Yeah.
most number of views and we go viral on TikTok for our scandalous takes on mice and whatnot. Thanks, guys.